requiring some states
to prevent voter discrimination.
We still need Section 5, and that's why we're here today.
It's been reauthorized by Congress 4 times.
4 times, most recently in 2006.
And that was just in 2006.
With an overwhelming majority of bipartisan votes.
What's happened since 2006?
Justice Antonin Scalia,
Clearly an opponent,
made a statement that cut through everything else.
The law is, and I'm quoting him,
Quote, perpetuation of racial entitlement.
some pretty incendiary language.
It's not judicial activism.
Totally backwards.
It's judicial megalomania.
Should we hear more from Republicans?
In the past, they've been more supportive.
What is going on with them?
The GOP seems to have lost some of its enthusiasm.
There's still forces in this country that want to take us back, but we're not going back. So we must never give up, never give in, never give out.
Good evening. I'm Chris Hayes in for Lawrence O'Donnell. The 13th Amendment to the Constitution was ratified the year the Civil War ended in 1865. It prohibited slavery. In 1868, the 14th Amendment granted citizenship to anyone, quote, born or naturalized in the United States. And in 1870, the 15th Amendment decreed the right of U.S. citizens to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. But administration of and the mechanics of voting is left to the states and localities, so the 15th Amendment gave Congress explicit authority to enforce it. 95 years later, in 1965, President Lyndon Johnson signed the Voting Rights Act to stop states and localities from using a bewildering and darkly ingenious set of laws and strategies to deprive people of the right to vote. Section 5 of the Voting Rights Act mandates that the worst offenders' voting laws be approved by the Justice Department or a federal court. It was reauthorized in 2006. The Senate voted 98-0. Between 1970 and 2000, the Department of Justice filed nearly 1,000 objections to voting laws. And in the last election cycle alone, the Department of Justice blocked voter ID laws in Texas and South Carolina, early voting cutbacks in Florida, and redistricting maps in Texas, all under Section 5. Federal courts agreed in most cases. But today, Shelby County, Alabama officials with legal representation paid for by a conservative activist told the Supreme Court that Congress was wrong to reauthorize the act because, basically, racism is now a thing of the past in the South.
I was 24 years old when we came under Section 5. I'm 73 last weekend, and we're still under the same formula, none of which has applied to us in many years.
Section 5 currently covers Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia, and some jurisdictions in 7 other states, including New York. During oral arguments, Justice Sotomayor articulated the original genius of Section 5 and its enduring logic today. Quote, Section 5 was created because states were moving faster than litigation permitted to catch the new forms of discriminatory practices that were being developed. As the court struck down one form, the states would find another. Justice Antonin Scalia, who said the court should be skeptical of Congress's decision to reauthorize a law because it would be politically damaging for politicians to vote against the, quote, perpetuation of racial entitlement for minority voters. And here was Reverend Al Sharpton on the steps of the Supreme Court today.
Last year, the voter ID laws and the long lines and the ending early voting and the stopping Sunday to the polls showed that Jim Crow's son, James Crow Jr. Esquire, is still trying to do what his daddy did, and that's rob us from the right to vote.
Joining me now is Judith Brown-Dianis, co-director of the Advancement Project, which focuses on democracy and race. And I just want to get your thoughts on oral arguments today. I mean, I think we knew going into this, the last case the Supreme Court, this court looked at on the Voting Rights Act, showed a tremendous amount of skepticism and outright hostility from many of the conservative justices on the court towards Section 5. I wonder, was today surprising to you?
No, not surprising. I mean, you know, you have Justice Scalia, I think, showed a little bit more of his attitudes towards Section 5 and towards race discrimination and race discrimination protections also. You know, his whole comment about this is a racial entitlement is just incredulous. I haven't known in this country that we have had a time where there's been actually some entitlements because of race. In fact, when we look at Section 5, it's protection. It's not entitlement. And then Justice Sotomayor, thank goodness she is on the bench. She was there as the advocate. Justice Breyer did a great job of really talking about the fact that we have not cured the disease of discrimination. So, no surprises, I think. So at the end of the day, we know it comes down to that one justice, Justice Kennedy.
And what did you think of Justice Kennedy today? I was reading, I read through the transcript, and he had a kind of famous line the last time this was up in the Numudno case, where he basically said, you are insulting the sovereign dignity of the state of Georgia. The Congress is valuing the sovereign dignity of Georgia as less than the sovereign dignity of Ohio because Georgia is covered under this provision, Ohio is not. And he said some things today that sounded similarly skeptical. And since we're all tea leaf reading, and because it will almost certainly come down to Justice Kennedy, what were your thoughts about what he had to say in oral arguments?
Okay, so I'm going to give you my prediction.
Okay.
My prediction is that
accountability moment. Roll the tape.
Uh-oh, don't rewind. So my prediction is that he will side with us on this, that he will uphold it, because at the end of the day, Justice Kennedy actually sometimes has broken ways with the conservative bloc, and he actually believes in fairness. Now, I'm not saying that in every case he's been fair. Clearly, there have been some race cases in particular where we have been concerned, but I think that at the end of the day, that fairness will rule, that there was enough information before Congress in 2006 to say that we still need a Voting Rights Act, and clearly we know, Chris, from all of the coverage that you've done, that in fact, in 2011 and 2012, we needed the Voting Rights Act to hold back all of those laws that made it harder to vote for voters of color. I want to bring in as well MSNBC's Reverend Al Sharpton, who attended oral arguments in the court today. And Reverend, I'm curious what your reaction was sitting there and listening to oral arguments.
Well, I thought there was aggressive representation on both sides. I was clearly outraged with Justice Scalia's reference to our having the protection of voting rights in historically discriminatory areas or districts referred to as a racial entitlement. But aside from that outburst, which I think clearly shows a deep insensitivity at best to what the Voting Rights Act was for and remains in effect for. I think that clearly there is, in my opinion, enough of a record there to show why we clearly need to continue to have Section 5. When you look at just the last election and all of the voter suppression schemes that disproportionately impacted black voters, and all of it being new laws introduced in 37 states, it shows why we must have pre-clearance and we must have the ability for the Justice Department that the Congress decided and reauthorized as late as 2006. They must have that authority to continue to protect those in those districts who have had various schemes to disenfranchise minority voters.
Well, one of the, you mentioned the raft of legislation in the last election cycle, voter ID laws, cut downs on early voting, almost always pushed through by state legislatures controlled by Republicans and signed into law by Republican governors. And one of the strange and perverse arguments being made by the plaintiffs in this case is that we've had such a rash of restricted measures taken in the places that are not covered by Section 5, that the differential treatment offered by the Voting Rights Act between those covered districts, like, for instance, the state of Georgia, and those that aren't covered, like, for instance, the state of Ohio, means that the Act's formula for figuring out what areas to target and which areas not to target for preclearance is outmoded or unconstitutionally haphazard. And Reverend, I wonder what's your argument that as someone who's been fighting against the voting restrictions happening outside of the covered districts?
Well, first of all, I think it's a bogus argument in this case, because what are you saying? If I am one that steals my defense in court is not that I didn't steal, but that everybody's stealing.
Right.
So you ought to let me go because you didn't get the other thieves. I mean, that is the most irrational argument that I've heard, and that is basically what they're saying. We're not the only ones doing it. Not that we're not doing it, we're not the only ones doing it. The fact of the matter is that these districts, clearly under the Voting Rights Act, Section 5, clearly were already designated and clearly continues to be a problem. And when you look at, and it was outlined very well, I feel, by the arguments today, when you outline the impacts that's still going on in Alabama, no statewide blacks elected, the disproportionate impact, they're clearly still someone or a district that has to be monitored and should be under pre-clearance. Now, if you want to make the other argument that it ought to be expanded to others, that's a different argument.
Right.
But how does that, in any sane argument, say that you should therefore now leave us to our own whims, that we are not even arguing may not still be there, and in fact would continue to disenfranchise voters that at least since 65 has been designated as voters that have to be protected by pre-clearance of the Justice Department.
One of the great ironies of this case is that the plaintiff, Shelby County in Alabama, actually, they are not, there's what's called a bailout procedure for the Voting Rights Act, which is that if you have a clean record for a sufficient amount of time, you can actually get out from under the heightened scrutiny, heightened scrutiny is a constitutional term, from the fact that you actually have to go through this pre-clearance mechanism, right? Shelby County could not, because as recently in 2008, they had a redistricting stratagem that led to getting rid of the lone representation from an African-American city council member. And Judy, there was kind of an amazing moment where Sotomayor confronted Shelby County about the fact that maybe the South has changed, but your county sure as heck hasn't.
That's right. And in fact, when you look at this bailout provision, and this is what's important in this case, is that under the Voting Rights Act, if you have not committed discrimination and you're covered by Section 5, you can bail out.
Yep.
There have been about 200 jurisdictions that have bailed out because they had a clean record. So Shelby County, too bad on you. You actually couldn't bail out because you have a history, and it's a present-day history. And so I think that this is where this case is going to come down to, is that Congress had enough information before it. President George W. Bush signed the reauthorization of the Voting Rights Act, Section 5. And so there was enough before them. Shelby County, clean up your act, get over it, stop discriminating, and bail out like others have done.
Reverend Al Sharpton, Hope to Politics Nation, 6 p.m. weeknights. Wonderful to have you here. Judith Brown, Diana. Thank you for joining me tonight.
Thanks, Chris.